Institute of Arbitrators. So when a construction project comes to an end, there are consequences. Who bears the costs? What happens to the works that are not completed, and very many other consequences. It's true, a construction contract does not last for eternity, but the way the contract comes to an end is as important as how it starts. To help us unpack and scrutinize this very solemn topic this afternoon, we are privileged to be joined by two speakers, one from law and the other from engineering, therefore highlighting the confluence and overlap between the fields of law and engineering. I'll go straight to introducing our speakers. Start by introducing Patience E. Akampurira. Patience is an advocate of the courts of judicature in Uganda with over 8 years of experience. She holds a Bachelor's of Laws degrees with honors from Makerere University and a diploma in legal practice from the Law Development Center. Patience is a senior associate at Kampala Associated Advocates in the prestigious Construction and Dispute Resolution Department. She's a member of Uganda Law Society, East Africa Law Society, the Chartered Institute of Arbitrators, and Construction Law Institute, Uganda. Patience has acted as counsel in commercial and construction disputes before arbitral tribunals and courts in Uganda and internationally. She is also a former representative for the organizing committee for the Africa Construction Law Conference 2025, which was held the month of May this year in the city of Nairobi, Kenya. Patience focuses on construction law and arbitration as her practice areas. She is a seasoned litigator, and she's also a banking lawyer and also experienced in the area of debt recoveries. Patience, you're welcome. Say hello to the participants. Our next presenter from the field of engineering is Engineer Alan Mugabe. Engineer Alan is a registered civil engineer with the Engineers Registration Board. His background is in civil engineering with over 15 years of experience, but 3 of those years focus heavily on construction law. Alan has a Master's of Science in Irrigation and Water Engineering from the Netherlands. For those who are aware, the Netherlands leads in water engineering, with nearly half of the country reclaimed from the ocean. So I think that the contract for redesigning of the Nakibobo Channel should have been given to Engineer Alan. I'll be glad to hear what you think about that. You can post your comments using the chat. In addition to a Master of Science in Irrigation and Water Engineering, Engineer Alan also holds a Master of Science in Construction Law and Alternative Dispute Resolution from the United Kingdom. And finally, he has a Master's in Business Administration from Uganda. Engineer Alan's expertise is in contract administration, from project contract management to design and specifications, to procurement, as well as project evaluation. And he has primarily worked within the water sector. Engineer Alan has acted as party representative in construction disputes in Uganda and internationally. He is a member of Uganda Institute of Professional Engineers, a member of the Chartered Institute of Arbitrators, and a member of Construction Law Institute. Engineer Alan, you're welcome.
Thank you, Fabian, and thank you all listeners.
Ladies and gentlemen, you can participate in the debate by sharing your thoughts, queries, compliments using the chat box. If you're very economical with words and communication, you can give us your reactions using emoji and emoticons. They're all very welcome. So let's dive right into the topic for the discussion, starting with Patience. Patience, what is termination and what does it look like in construction?
Thank you, Fabian. I hope I can be heard loud and clear. Termination in construction law is unique in its own way, because you have to understand that this is governed by the different contractual provisions. So before we can understand or delve into our topic for the day, I would like briefly to highlight the key parties to a construction contract. And that will be important because it will form a basis for our discussions as we go on. So the key parties to a construction contract, that is the employer, who can also be known as the client. And this is the person for whom the works are being done. It can be to construct a house, a road, repairs of the whichever building it is. It could be an entity, which is a legal person, or it could be an individual. So that is simply who the employer is. So you'll keep seeing such terms in construction materials. And then the other party, the other key party is the contractor. So the contractor is the person or company who is hired to carry out those services. And again, the services vary based on what the employer is looking for. So when the two come together and agree on the specific works to be done, the relationship or the agreement that they enter into then makes a construction contract. So those are the key parties. But the other party that is important to be mentioned is an engineer. Now, here, an engineer is used as a technical term because this is the representative of the employer during the construction project, but also the engineer plays a key role as the contract is ongoing. So the three, you should bear in mind: the employer, a contractor, and the engineer. Those are the key three parties. Now, once they have entered into that contract or agreement, of course, issues arise. People disagree, things happen, and you're likely to want out of that agreement. And then that's what then takes you to termination. But also for a clear understanding or extensive understanding of what a construction contract is, the Housing Grants and Construction and Regeneration Act of 1996 UK, under Section 104, defines the different ambits of a construction contract. So you can look at that within your free time. Now, going to termination, Fabian's question. So termination then is where either of the parties, and that is the contractor or the employer, decide and say, you know what, because of reasons A, B, C, D, I am going to get out of this contract. And either of them have the rights to do so based on the contract they're looking at, or based on the operation of law, based on the nature of the relationship, they both have the obligation, not the obligation really, but they have the right to terminate the contract if certain circumstances arise. So briefly, in simple terms, that's what I would consider as termination of a construction contract. So that relationship for which the parties had come together for is brought to an end. So if it was construct a house or a hotel or a road, then that relationship has been severed and has come to an end. So that is what is called termination of a construction contract. So then once you understand what that term is, then you have to bear in mind that the termination takes different forms, yeah? And what do I mean by taking different forms? The forms or the nature of termination would depend on the contract that you're dealing with. Why do I say the nature of contract? It's because there are standard construction contracts, which are internationally recognized. And the common one that is used it's the FIDIC suite of contracts. Why do I say suite? It's because there are several. There is the red book, green book, pink book, white book, emerald. So it's a suite, the rainbow suite. So there are quite a number. But specifically for purposes of this discussion, for today's webinar, we will draw examples from the red book, the 2017 edition. And it's the one that we'll keep making references to for purposes of our webinar. So again, when you look at under the red book, you realize that it gives you an option to terminate, which is contractual. Here, it's contractual because you have a contract that you've entered into. And in this case, that is the red book. But practically, you find that you have the special conditions of contract and then the general conditions of contract. So you will have two documents that then make a construction contract, of course, in addition to other documents. But those are the key documents that you need to consider as your construction contract. So basically, termination of a construction contract will take two forms. And these forms, first, it's the contractual. There's a contractual option where you can terminate the contract under the contract. And then there's also by operation of law. Now, at the back of your mind, you need to remember that the three parties that we mentioned, actually, let's restrict it to the two, the employer and the contractor, they all have specific obligations that they're supposed to perform under the contract that they have entered into. So it's as a result of failure to perform those obligations or failure to adhere to the provisions of those contracts that then will result or will bring up the requirement or the need to terminate the contract. Now, under the contractual option for terminating, again, it also has three options. It has the termination for default, and for termination for default, both the contractor and the employer have the liberty to terminate under termination for default. Then there's also termination for convenience. Now, you need to remember that termination for convenience is only restricted for the employer. The contractor is not given the mandate to terminate under the Red Book 2017 to terminate for convenience. Then the other termination under the contract is optional termination. Now, the optional termination is also available to both the contractor and the employer, and this is specifically restricted to exceptional events. So that's also one of the other modes of termination of a construction contract. And then, of course, so it's those three elements, those three, can I say, subsections or subtopics that then make up termination under the contract. So that's how you would then be dealing with it. And maybe Fabian can guide how much time I still have left so that I can briefly highlight each of them.
Patience, you're doing so well on time. You have 5 more minutes.
All right, thank you very much. So briefly, looking at termination by the employer under the Red Book 2017 suite, and maybe what I should have mentioned, participants must be wondering, what is FIDIC? So FIDIC is a French acronym, and it stands for the International Federation of Consulting Engineers. And this is an international organization that has for the longest time set up standards for the construction and the technology industry. So that's what FIDIC is. So when I say FIDIC, bear that in mind, that's what I mean. So an employer under clause 15 of the 2017 suite is allowed to terminate a construction contract. And one of the grounds for which they can terminate is if a contractor fails to provide a performance security within the agreed time. Now, briefly, a performance security is either a guarantee, it's a bank guarantee or an insurance bond that is given by the contractor to the employer, and it is meant to be used essentially as a security. In the event that the contractor does not perform the works, then it's a fallback plan for the employer, so they can recover against it. Now, there are timelines within which this security is supposed to be provided. So if the contractor fails to provide it, it's one of the grounds for terminating a contract. The other one is subcontracting all the works, all part of the works without getting consent. This is very important because you as an employer, you've gone out and outsourced Alan's skill and expertise, and it is Alan that you want to do the works. So for Alan to go and get Fabian to do the works without your consent, it puts your project at a risk, that's one, but also it exposes you to certain liabilities that you have not been party to. So subcontracting is very important. You should always pay keen attention to your contract and see whether it's allowed with consent or if it's prohibited at all. The other one is, of course, if you fail to correct defects. Now, defects, these are they will happen during the course of the project, and the engineer, the other party we referred to, has the mandate to issue notices for you to correct them. So if the contractor continuously fails to adhere to these notices, the employer can terminate. And then lastly, the other reason would be bankruptcy if it's an individual who is a contractor or an employer. Now, we have kind of cases where the employer had to terminate because the contractor once subcontracted all the works without consent. Also, they abandoned the site, so they literally left the works and they were not performing. But the other one, they failed to adhere to the notices to correct, and these were about 4 notices. So the employer exercised their right and they terminated. For the aspect of subcontracting or assignment, you can look at the case of NSSF versus Alcon. It emphasizes the principles and the need for adhering to the contractual terms regarding subcontracting and assignment of construction contracts. That's a very locus case in Uganda regarding subcontracting and assignment. And now I'm going to then go to termination by the contractor. Now, a contractor can also terminate. A contractor can terminate also if the employer, one, fails to show that they have reasonable available funds to pay the contract price. This is referred to as financial arrangements under the FIDIC book. So that's one of the grounds. Also, a contractor can terminate the works. Excuse me. They can also terminate the works in case the employer is bankrupt or is insolvent, or if the employer within a period of time fails to give the contractor commencement. Commencement is when the works start. So that's also one of the reasons. The other important one is failing to make payments within the agreed time. Why is this important? Because as a construction project, you cannot run without money. So the employer should endeavor to pay you as and when the certificates are certified and they are raised by the engineer. So that would be what a contractor can terminate under. The other one, I briefly highlighted it, which is optional termination for occurrence of exceptional circumstances. Now, this one, you also find it under the red book. It is also highlighted, and it gives you the examples. So you look at it and try to understand what are those events that can entitle you to exercise optional termination. That is under the red book as well. So lastly, I'm going to look at operation of law. And under operation of law, of course, you're looking at frustration of purpose. You may have to terminate, actually not may, the contract will terminate automatically. For example, due to failure of frustration of purpose. If you are doing a contract for us and the purpose has ceased to exist, then you cannot continue. The other one may be death. If your contractor is an individual, if a contractor dies, you cannot proceed with the work, or the employer. Then the other one may be illegality. Let's say if you are putting up, let's say, what example can I give? If you're putting up not a hotel, but like a building for certain business, and now the government has said this is now illegal, you can't do this anymore. So that automatically then, by operation of law, you cannot continue with the construction project. So essentially that would terminate the contract. So briefly, that's what Fabian, I would give as different forms of termination of contracts. And lastly, of course, the termination for convenience. Again, I mentioned it's a preserve of the employer only, and it is covered under clause 15.5 of the Red Book 2017 edition. Yes, that's what I would look at as the different forms. Maybe just to emphasize, the 2017 edition introduces something important for a contractor under termination for convenience, where it allows the contractor to recover loss and loss of profit if the employer chooses to terminate for convenience. Now, this was not in the 1999 version. So this is a plus for the contractor, because if you're terminating for convenience, then I should be compensated for the losses or the profit that have incurred as a result of your action. Back to you, Fabian.
Thank you very much, Patience, for that elaborate introduction to the topic. You have you have shared with us about the parties to a construction contract, the employer, the contractor being the main parties, and the engineer who plays a special role. You have informed us that there are circumstances whereby either by operation of the law or under the contract itself, a party would wish to bring the contract to an end, and you have based your discussion and your examples from the FIDIC Red Book 2017. The audience is asking what FIDIC Red is, but Patience, I'll give you an opportunity at the end to explain further what FIDIC contracts are. I thank the engineers who are answering the questions in the chat. Please keep the discussion going. I'll now move straight to our second speaker, Alan. Now that Patience has started the ball rolling, engineer, what are some of the pitfalls that a party intending to terminate a contract should watch out for? You guide us through the landmine of termination of a construction contract.
Thank you, Fabian. I'm going to try to do my best. I hope I'm audible and clear to everybody. My co-presenter will take us through the broad categories of termination later. But for this discussion, I'm going to limit my discussion to one category, which is the contractual right to termination. And also, just like Patience has said, I'm also going to try my best to stick to the 2017 FIDIC Red Book, which is a form of contract, which Patience will again tell you about. But this FIDIC 2017 Red is specifically one where works have been designed by the employer or his representative, and that is the engineer. There are other forms of contracts. There are the PPDF forms of contract. There are also others in the region and any other country. But all forms of contract do have a way or a clause of dealing with termination. So always ensure that you have looked at the 2017, that you have looked at the termination clause of this particular contract you're discussing before going on to carry out termination. So going back to our question, what are the common pitfalls that a party should watch out for? It's very important to know that while termination is acceptable, carrying it out wrongly or by the wrong person can also lead to a dispute or lead to costs. For example, if you do not follow the correct procedure that has been set out in the contract, let us say you have actually been breached, give an example, and you have a right to terminate within 14 days, and you actually exceed the 14 days, then your right to terminate has expired. You no longer have that right. So it's very important that termination is carried out as accurately and as specified in the contract. I have been in some contract situations where everything has been done correctly, but you find that the person who has signed the contract is not the person with the right power of attorney. That is a form of dispute because that means that the termination cannot be enforced. It's null and void. So depending on which party you are, Patience already told us that you can be the employer or the contractor. If you're the employer, make sure you follow the right process, which is your engineer should issue a notice to correct. Then you should issue after a number of days a notice of intention to terminate, and then finally give your termination notice. If you're the contractor, you're free to do your suspension notice, and then after that, do the termination notice. Please, and all those who are listening, ensure that the right person gives the right notice. By right, I mean that the person with authority to do so under the contract. For example, if the person named in the contract as the contractor's representative is Fabian, and Alan is one of the staff of the contractors and writes a termination notice, it is invalid. So be very careful who writes the right contract. Another pitfall which you should watch out for as you terminate the contracts or try to exercise that right is if one party has already given instructions and the termination has been effected, but you continue to perform the contract. For example, you give a notice, please put this ladder here, please put that, and those instructions are not consistent with the termination clause, then that also means that you're waiving that right to terminate. It is important that those instructions you make after the termination has been effected, because there are some notices that you're supposed to make or instructions. For example, you have to keep the site safe. You're not going to leave a pipe running with water or burst because you've terminated the contract. That's a big loss. So you have to make sure the employer is allowed to give an instruction for the contractor to make the site safe before he actually leaves the site. Another thing that you should know, another pitfall is that you should know is that the termination does not mean that the works will remain incomplete. Employers or the client has to go through another procurement process or a selection process to get someone else to do the job. During all that time, you should know that the engineer who administers the contract on behalf of the employer is on site and has to be paid. So all I'm showing you is that everything that leads is becoming more and more costly. It's very important that before you conduct the termination, you should audit all the materials and equipment. If you fail to do that immediately from the cutoff date, it can also create disputes over valuation. What has the engineer found? What did the employer leave? What did the contractor? Finally, before I leave this at this, I would like to let you know that the parties' relationship is destroyed. For example, you are a contractor, you're working with maybe a client. Even if you are the best contractor and the termination takes place, on the follow-on contracts, it will be very hard to have that business trust that you had before as two parties. So please avoid termination whenever you can. Thank you, Fabian.
Thank you very much, Alan, for that very insightful presentation. Alan, there's a question here from Moses Senoga, directed to you. Says, despite construction contracts having provisions of termination, many employers tend not to opt for termination as the first option. Why is this so? You could just give a brief response and then move on.
Okay, thank you, Moses, from the audience. This shows that you're following. So termination is very costly. And I will discuss this later when I go on to make further presentations. But termination is generally very costly. It affects the workflow. For example, you find that when you terminate a contract, the services or the benefits from the project cannot be realized until that project is actually completed. That means in law, some people call it pure economic loss. There will also be losses, which are damages, but there will also be the pure economic loss, the loss of benefits. For example, Moses, if you're a football fan, I can imagine if you're building a stadium and the stadium is not ready by the time people are going to buy tickets to come and watch a match, but imagine the stadium is not ready. So that means that you would have lost all those rights to even broadcast such. Yeah, I hope that clears.
Thank you very much, Alan. And Patience, there's a comment from Manigaruhanga Godwin. I believe you'd be the best person to respond to this. Says, in the circumstances where the contractor is dead, yet I had paid him or her all the money for the construction, what will be my remedy? Just briefly, Patience.
Thank you, Fabian. That would be very unfortunate. But legally, what that means is that then you have a claim against the estate of the person. Now, when I say estate, I mean the legal representative that is going to be appointed to come in to manage the affairs of the dead person. So if your contractor died with a will, then they will apply for letters of probate. Or if they didn't have a will, then they would go for letters of administration. And once either the administrator has been appointed, then you will have to bring a claim against the estate of the administrator, because you cannot sue a dead person, unfortunately. So until those processes have been done, that's when you can claim for your money. But you see, the beauty with construction projects, you're not going to pay the entire contract sum at once. No. Even if you've agreed and said the project is 10 billion shillings or $10 million, what happens is that there are documents which are called interim payment certificates. And just like the word says, interim, it means for every phase of work that you'll do, it will be assessed and valued and certified by the engineer. And then the contractor will submit these documents to the engineer for verification and confirm that they are accurate. And then they will only be paid against that certificate that has been made. So you shouldn't worry that you've paid your entire contract sum and now the person is dead. No, the payments are periodic. They don't all happen at once. So that's also an upside of the nature of construction contracts. Thank you, Fabian.
Thank you very much, Patience. And Patience, before you hand over the microphone to Alan, Alan has emphasized the importance of following the procedure in the contract to the dot. Could you please take us through the procedures for terminating a construction contract?
All right, let me do that. Maybe Fabian, with your guidance, and if you allow me, there is one of the participants who made a comment about financial arrangements, and I wanted to point the participants to a case that can help them understand financial arrangements. I didn't get the name. Yes, but yes. So it's not that you can only terminate. It's not that you can only bring up the aspect of financial arrangements when the employer has failed to pay. No. Under clause 2.4 of the Red Book 2017, it's one of the fundamental obligations of the employer. They have to adduce reasonable evidence to show that they have financial arrangements to meet the contractual obligations of the contractor. And this means that as and when you raise the payment certificates, they'll be satisfied, and this means that they will be paid. And it's very important because I'm going to refer you to a case. It's called NH International Caribbean Limited versus National Insurance Property Development Company. This is a decision by the UK Privy Council. This is the Supreme Court of the land. And in this case, the arbitrator upheld the contractor's ground for terminating due to the employer's failure to adduce reasonable evidence of having what's the word? Financial arrangements. Yes. So that's a very important case, and I would request that we all look at it. It will help you understand what it means to adduce sufficient evidence, reasonable evidence, I beg your pardon, but also the need to adhere to the timelines within which you're required as the employer to adduce these financial arrangements. So I wanted to make that clarification for the parties to understand. That case is it's a very good case on financial arrangements of the employer as an obligation. Thank you.
Thank you very much, Patience. You could now proceed and take us through the procedure for termination.
Thank you. All right, thank you, Fabian. Now, again, you recall that both the employer and the contractor can terminate the contract. So under the Red Book 2017, there are procedures that need to be followed. And like Alan has emphasized, it is important that you follow the specific procedure that has been provided by the contract and which is governing your relationship. Why this is important? It's because, like Alan said, if you don't follow the proper procedure, the proper processes and the timelines and the procedures, there are a lot of consequences that can flow, both practical, financial, and legally. So it's very important that you read your contract. If you aren't able to read the contract, get people to help you with this, get services to assist you in understanding your contract. Now, so I will go to the procedure which is taken by the employer in terminating a contract. Why am I starting with the employer? Because they are the money bags. They're the ones who have asked the contractor to come and work. So I will start with the employer. Now, specifically under clause 15.2 of the Red Book 2017, it allows the employer to issue a notice to terminate. Why a notice of intention to terminate? Is because it gives a period and it gives 14 days. So within these 14 days, the contractor has a final opportunity to rectify that which the employer is complaining about. Now, you remember the different reasons which we looked at for which you are able to terminate a contract. So for example, if it's you failed to rectify a defect, you can use the 14 days to rectify them. If you failed to provide a performance security, you could use that period. So the 14 days period is the last opportunity to the contractor. In the event that again, before I go to the other option, it is important that when you're drafting your claim, it's in simple terms, it can easily be understood, but also you need to specifically state the clause under which you're preparing this claim. Why is this important? Notice, my apologies. Why is this important? Because if you cite clause, let's say if you cite clause 14.6 and you're terminating under that, that is wrong already. So me as the contractor or as the lawyer for the contractor, the first ground I'm going to raise, this is wrongful termination. The clause does not give you the right to terminate. So it is important in your notice, clearly state you're issuing this notice of intention to terminate under clause 15.2. That one, there is no way of going around it. You must clearly state it. So again, if the contractor does not comply with the 14 days, then what you do as the employer, you issue the second notice. Now, once you issue the second notice, then the termination happens, and the date of termination of the contract will be taken as the date on which the second notice is received. Now, you need to remember the other party we talked about is the engineer. So the engineer, these are some of the powers or the obligations that they're allowed to exercise. Again, you need to refer to your contract and be clear as to who has these powers, who can issue these notices, who can and who can't, like Engineer Alan emphasized. So that would be where you issue a notice. Now, also an employer has the right to terminate immediately. This is also allowed under the Red Book FIDIC 2017 version. And when can they terminate immediately? If you're as a contractor, you're an individual and you're being declared bankrupt, or if you're a contractor and you're a company, you've been declared insolvent, or you've gone under receivership, you've gone under liquidation, then the employer has to terminate immediately. The other reason for terminating immediately is where the contractor subcontracts all the works or a fundamental part of the works. Again, this is you're doing the subcontracting or the assignment without the prior consent or agreement based on what the terms of the contract said. So under those, then the last one is if there is reasonable evidence for fraudulent activities, practices, or corruption. This is a very big one. If it can be proved that you as a contractor, you are involved in fraudulent practices or corrupt practices, the employer is allowed to terminate immediately. And this means you don't have the last opportunity of the 14 days to be allowed to rectify the defect or the reason for which they want to terminate. So that is one of the reasons. And so if those exist, then the employer can terminate immediately. And your argument that I did not get the 14 days notice will not suffice because the contract is express. You can terminate immediately under those grounds. Then now, if we look at termination, the procedure for terminating by a contractor, similar procedure. Why is this similar? Because both parties have obligations and they're both required to perform them. There's no exception. If you're required to do the works within a specific period of time, you should do them. And one thing we need to emphasize is the aspect of time. In a construction project, even one day makes a whole difference. So time is everything. So you must adhere to the specific timelines that are being listed under the different clauses that you're going under. Time cannot be overemphasized. So a contractor, so the procedure for a contractor to terminate, similarly, you issue a notice of intention to terminate. This is under clause 16 of the FIDIC book. And again, you must state the clause under which you're issuing the notice, one, and you must state the ground on the basis of which you're issuing this notice. When I say ground, I mean for example, the case I've just mentioned, in that case, the contractor had specifically said we are issuing this notice of intention to terminate because the employer has failed to adduce reasonable evidence for financial arrangements. So you need to be as express as that. You can't afford to be vague about the reason why you're terminating, because then that could also render your termination illegal, and then other issues will come up. So again, the employer also has that opportunity within 14 days to rectify the defect. And if they failed to, if you don't comply with the 14 days, then the contractor may. Now you need to note that the provision says may issue a second notice. Now, if you're to look at it legally, may is optional. It's not mandatory. If it had said shall, then if I failed to issue a second notice, you would hold me culpable and say, look, Patience, you did issue me a second notice, so you cannot terminate. But it has said may. So I may take it that once the 14 days have lapsed and you have not rectified the defect, you fail to comply. So I would say, in my opinion, that you can actually render the contract to be terminated after those 14 days. But because it says may, and you don't want to have to make certain arguments as the one I am making, it doesn't do any harm to issue a second notice. So you issue the second notice, and the termination of the contract takes effect on the date on which the notice is received. Now, just like the employer can terminate immediately, so can the contractor. The contractor can also terminate immediately if there is reasonable evidence that the employer was involved in fraudulent or corrupt practices. The contractor can terminate immediately. If the employer is rendered bankrupt, if they are an individual or insolvent, and you must be wondering, what is bankruptcy or insolvency? So briefly, for an individual to be rendered bankrupt, Fabian, sorry, I'm going to use you as an example. If Alan, engineer Alan, hired me to do his works, as the contractor. So in this case, Engineer Alan would be the employer. I am the contractor. Now, if let's say we have a company, Fabian and I, we have company FP. If FP fails to pay its debts or claims that are brought against Fabian and I as the company, you can go to court and ask court to render us insolvent. Why? Because we have failed to pay the claims or the debts as and when they arise. So then we would be insolvent. Now, if I'm to use the example of Fabian and Alan, if Engineer Alan is the employer and Fabian is the contractor, and now it turns out that Engineer Alan is not able to pay Fabian as and when he makes his claims and other individuals, then Engineer Alan can be rendered bankrupt by court. So bankruptcy is for individuals and insolvency is for companies. Similarly, liquidation is also for companies. Liquidation means the company is being closed and you're selling everything it has to pay off the creditors. Also receivership, similar terms. So those are some of the grounds on which you can terminate immediately as a contractor. The other important one is prolonged suspension of works, which affects the whole works of the project. And this makes sense because if you suspend works over 4 months and the entire project is shut, you as a contractor, you're incurring a lot of costs. You have idle staff, you have idle equipment. It means you're not being paid because you're not working. So also that, but also based on the period, the time periods under the contract, you're allowed to terminate for prolonged suspension. And then lastly, you're also allowed to terminate immediately if the employer subcontracts or assigns the works. So if Engineer Fabian decides to give me the contract that he had given Fabian without Fabian's consent or approval, Fabian can immediately terminate the works. So those are some of that's the procedure for the contractor and for the employer that has to be followed in terminating a contract. Now, again, like Engineer Alan emphasized, it is the contract under which the two parties have entered that would determine these procedures. So we are using the Red Book 2017 for specificity for this webinar, but you need to be mindful of the contract which you're using as the two parties. Thank you very much, Fabian.
Thank you very much, Patience, for that elaborate presentation. My takeaway is that when it comes to termination of the construction contract, the devil is in the details, and procedural non-compliance is a deal breaker. Therefore, parties should engage professionals, engage construction lawyers, engage consulting engineers, engage FIDIC-approved contract managers, so that you are advised on the rights and the procedures before you proceed with a termination. There's a comment from Jackson or Joke. He says that for the dead contractor, first of all, my client wouldn't love to engage with an individual contractor. You contract with a company. In the death of a director, business may not be as usual, but the system does remain in place. I believe what Jackson is saying is that avoid contracting individuals in construction works. Engineer Alan, would you agree?
Yes, I would agree. Use companies.
All right, then, Engineer Alan, this question is yours, and once you have answered it, you'll proceed and you tell us what the consequences are for termination of a construction contract. The question is from Tilton Laura. Laura's question is a bit long. It starts, government has a tendency to discontinue government entities, for example, NADS, without giving any communication to the contractor on who the new client is to be. So, is the contract still valid? And if you are to terminate this contract, who will be getting the termination notice since the client no longer exists? Please, Engineer Alan, that is your question, and then you'll tell us about the consequences of termination of a construction contract.
Okay, thank you, Tilton B, for that question. So this is what happens when the contract has provisions. I'll just point to the FIDIC contract. There is 1.4 deals with the law and the language. So it deals with the law under which the contract is being operated. Then another clause still under the 2017 that is important for this to answer this question is clause 1.7, which deals with assignment. Now, when NADS has been discontinued, there is usually an act of parliament that repeals NADS, and maybe, but in that it will state who is going to take up any liabilities or benefits that NADS had. In that repealment act, now that means that in your FIDIC contract, you're operating under the law of Uganda. So now if that act has now been repealed by parliament, that means you now follow. Then you go to 1.7, which is also a clause under the contract, which deals with assignment. When this repealing is being done, they will assign the benefits and of the contract to the new person. So for example, this could go to Ministry of Agriculture, I guess, or whichever other entity or authority has been created. So yes, in case of any termination notice, now that will be the new client. And always they make fresh contracts, which are also cleared by the Solicitor General and then issued to the existing contractors. All right, I hope that settles it, but feel free to add on later. Fabian, going back to the question about the consequences of termination in a construction contract, Patience has been very detailed and told us the various ways: the termination by the contractor, the termination by the employer, which includes convenience and breach, and maybe the governance challenges. So I'm going to try to highlight the consequences under each. I'll just try to list them because I see time is catching up with us. So the consequences of termination by the contractor. When the contractor terminates, this means that the employer will need to find another contractor to complete the work. This work must be completed. It has been budgeted for. In case this contractor had a subcontractor, that means this employer will also need to deal with that subcontractor. Sometimes it will be more than one subcontractor. There could also be another issue, another consequence could be that there will be legal costs. Suppose there's something unclear, if there had been any poor management like we had discussed, it means that legal costs will be there. These costs could be costs related to adjudication, to arbitration, and litigation. So those are all consequences. As you can see, and the audience, I hope you're paying attention, everything that I say is cost. Somehow there is cost coming up. Every consequence is most likely costly. There will also be a requirement to do valuation and payment subject to the relevant subclauses. So that means you do not say, oh, now that you've terminated the contract, I'm not paying you, you go. No. You still have to pay him for what he has done. Termination discontinues future contractual obligations, but what has been done must be paid for. Please, those who are listening, please ensure that you do not say, no, now that you've terminated, you don't want to deal with me, I'm also not paying you. No, that is also a reason for dispute, okay? Sometimes, and I'd mentioned this a bit when I was discussing, you might have reached and you've constructed a bridge, but you've not put the guardrails on either side of the road. That means that bridge is not safe at that point. So even if the contractor terminates, you as the employer, you will still need to instruct him under the relevant notice. Please go ahead and make this bridge safe. I am going to pay you for it, but please put the guardrails on the side so that it is safe for pedestrians and motorists to use this road. Another consequence, which could be the last, under termination by the contractor, is silent blacklisting. Like you said already, when the contractor says I'm terminating, the employer already doesn't want to even deal with him anymore. So what are the chances that you'll deal with him in future projects? And if you look like at our country, we have a few very large contractors. So imagine you terminate with each of those. Then that means you not have anyone to do work for you in the future. So be mindful. Generally, termination, everything becomes too costly, and these costs are still not contributing to the work. So remember that our road has to be completed, but now we are diverting money and spending on legal costs, spending on other instructions, but not dealing with the actual service. Another thing which was well described is termination by the employer. So that was the ones I've discussed were, if it is the contractor who was terminated, what are the consequences? Now, what are the consequences if it is the employer who terminates? So remember, the employer can terminate for about 3 issues. One is convenience, breach, and governance challenges. So I'll start with convenience. If you said no, because the employer is allowed, unlike the contractor is not allowed, but the employer is allowed to say, oh, okay, no, I don't want this work to continue anymore. That is it. The employer has that right, and it is within its contractual. Whereas the contractor can't do it, the employer can do it. Now, what are the consequences? First of all, if you tell the contractor, stop for convenience, no reason, there's no problem, but for my convenience, you are fired. What does it mean? You have to compensate the contractor for what he has done, even if it was not related to profit. I mean, not related to actual works. What do I mean for what he has done? For example, the contractor could have moved his equipment from, let us say, Luzira, and taken it and his resources to Arua, where the project site is going to take place. Now he's already there. He has built a camp. So you have to pay him that cost that he has incurred, even if that cost is not contributing to actual work. I hope you understand me. So you're paying him for taking his equipment and taking it back to Luzira. To make matters worse, let us assume this contractor is from Asia or Europe, but he had brought his equipment from Luzira. You have to transport that equipment back to his location. So you have to incur the cost of paying his equipment and his resources to take them back to Europe or to Asia. So be careful when you're terminating contracts for convenience, because the consequences are high. Another consequence for termination for provision. Sometimes in the contract, there is an amount included of profit, a percentage. So you have to compensate him for his profit, which is a percentage of what you're paying him, cost and profit. If it is not stated, the minimum is 5%. But if it is stated, it will even go as high as 40%. That means you as the employer, you're going to pay 40% of the contractor's cost. Take back his performance security, and now you cannot liquidate it. So it means you give it back to the contractor. You say, look, I'm not, it is me who has terminated. Here is your performance security, go. So be very careful when dealing with contractors. Whereas the clause allows you to terminate for convenience, do not exercise it without reasonable reason. Okay. Another reason, if you terminate, if you're the employer, but now terminating for contractor's breach. Now we've gone out from the convenience. Now the contractor has breached. So he has done something wrong, which you had stipulated in the contract and said, if you do this, I'll terminate. Now, first of all, here, you are allowed to liquidate the performance security. Patients mentioned about the performance security, which is given as a collateral from a bank or a financial institution. It could be usually it's 10% of the contract price, depending on what the parties agree. Now the SOP PPD has made some amendments, it's now 5%. You will take back that. If the contractor has breached, you are allowed as the employer to write to the bank and tell him to cash that security, as long as it is still valid. So again, if you're a contractor and you want to terminate if you're an employer and you want to terminate a contractor for his breach, do not terminate unless the performance security is valid, because you have, much as you recover, that's one of the quickest low-hanging fruits to pick. That's one of the easiest ways to recover. So first, even if you want to exercise that right, please make sure the performance security is valid, because another thing is that you still, even if the contractor has breached, you still have to pay him for what he has done. So that is the completed works that I've said. Again, you have to know, you remember we're dealing with the 2017 Red Book. How are you going to pay the engineer while he's away or while you're finding another contractor to do the works. Remember, you had a fixed budget. Sometimes this money is from donors. Maybe they will consider some costs ineligible. Will you be able to get some additional financing, maybe from government or other donors to meet that cost? Another thing which I can think, I already mentioned this, I'll just list it. It's the dealing with disputes in case of the mismanagement. Our third related consequence to governance challenges, this is corruption or bankruptcy that patients highlighted. These are few, just prepare the claims. If there are any claims, unsorted works, deal with them. And another consequence is value and pay. Corruption and the bankruptcy or insolvency, as it was generally highlighted, there's nothing much you can do. Just do any claims that are pay and contract terminates. Thank you.
Thank you very much, Alan. My takeaway is that termination equals costs. And I take it that the termination we are talking about here is not termination by completion of the project. Please just be sure about that, engineer.
Yes, it's not termination by completion, it's termination in the middle of a construction project.
Thank you very much for that clarification. Now, Davis Karashani has a very interesting question, and I think when he typed this out, he had patients in mind. The question reads, how would one prevent termination for defaults caused by third parties, such as thieves? For example, in scenarios where people don't take out insurance. It gives an example of installed drawers getting stolen and the employer can't take possession or make use of his premises. So the client tries to terminate the contract to prevent paying any other fees. I think the question here is, can you prevent termination for defaults caused by actions of third parties, such as thieves? Patience.
Thank you, Fabian, and thank you, Davis, for your question. I think the starting point in answering this question is what are the obligations of the parties? That is the starting point. And Alan, and like Alan mentioned, Engineer Alan mentioned, is as a contractor, one of your obligations is security of the site. So you as the contractor, you are required, it's a contractual obligation. You're required to provide security for the works, for the site of the works during, whether it's at night, during the, throughout the entire project. So as the employer, if a third party who is a thief, comes and steals properties or anything from the site, then the blame goes to the contractor, because I don't know the third party. I have no relationship with the third party. Again, the blame will fall on the person who was responsible for ensuring that that event that has happened does not happen. So I would say it falls on the contractor, because security, providing security for the site, is an obligation of the contractor. But also important to note, he talked about where there is no insurance. I think as an employer, you should not compromise on certain contractual obligations. Why do I say this? And one of them is insurance. This is important because you are not going to be responsible or in control of events such as this. So if you as the employer, you waive or you don't incorporate an obligation for the provision of an insurance policy, then you're putting your works and your project at risk. Again, the insurance policies that are included in construction contracts are very wide. One, it's against such things like theft, protecting workers' compensation, because your employees may fall into a ditch, something may happen to them, debris may fall on a third party. Who is responsible for such? So you as an employer, you cannot expose yourself to such liabilities and also to put your site at risk by foregoing insurance. Yes, a contractor will convince you and say, it's not necessary to have these insurance policies. But again, that is why it's important for you to have advisors or consultants or professionals who know the importance of getting such things, and insurance is very important. But again, to conclude the answer, the contractor will be responsible in this case for the thieves, because he or the company are the ones responsible for the security of the works. I hope I've answered the question.
Thank you very much, Patience, for that concise response. My brother Agaba Gerald Kachima has a very interesting question, and I'll address this to Engineer Alan. Question reads, in case an employer terminates before handing over the site, after getting information that the contractor has no capacity or experience in the area, shall a notice be necessary in the circumstances? For instance, if the contractor indicated similar works done with other clients and the employer discovers that they had actually not performed such works. Alan, the gun is loaded.
Thank you. Thank you, Fabian, and thank you, Agaba, for that question. So remember, as long as the contract has been signed, everything you do has to be done within the ambit of the contract. So you have to follow the procedure that has been laid out in the contract. However, the issue of saying that the contractor indicated similar works done with other clients and the employer discovers that they had not actually performed those works, as long as the employer has evidence that the contractor had not performed those works, now this becomes fraud. Now, remember, one of the things where you're allowed to terminate without even giving a notice to correct is under if someone has done any misrepresentation or fraud or corruption. So this would be still follow the procedures in the contract, remember, and give the evidence why you think that the person has been fraudulent. Remember, it must be backed by documentary evidence and proof. Thank you.
Thank you very much, Alan. Now, that issue of fraud is making Hanning Babietsitsa very uncomfortable, and she has shot a question to Patience. The question reads, hello, Patience, you submitted that one of the grounds under which a party can go for immediate termination is where there's fraud on the part of one of the parties. Given that fraud requires proof of fraud, can't a party challenge the termination on grounds that he or she has not been found guilty by a court of competent jurisdiction for fraud? Patience, please, the microphone is yours.
Thank you, Fabian. Again, and she makes a very important point, because we all know that the standard for proving fraud is high. That's one. But also the framers of these contracts were aware of that. And they specifically say reasonable evidence. So you have to have reasonable evidence to show that the contractor or the employer has been involved in fraudulent practices. Now, again, one thing I need to maybe bring in now is that construction contracts don't automatically go to court immediately. No, there are mechanisms, dispute resolution mechanisms that have been provided, and some include you go before a dispute adjudication board or an arbitrator, and this is where you'd be able to lodge such defenses to your termination. But you see, because the contract says termination is immediate, what would happen is that you as the contractor, then you follow the mechanism that has been provided in the contract to challenge the termination. And because it's immediate, you cannot then stay on the site. Unfortunately, the consequences or the effects that Engineer Alan highlighted kick in. So you as the contractor, you have to leave the site. They do the reconciliations, the valuations, they pay you for your money, and the handover happens. Now, you as a contractor who is aggrieved, and in your opinion, or you think that the termination was not justified, then you would follow the dispute resolution mechanism that is available to you. And for example, you go for arbitration, so you would then go and say, look, you said I was fraudulent for ABCD, but I didn't do ABCD. And if it happens and turns out that indeed the evidence that the employer had adduced does not then prove that you are fraudulent, then you would be entitled to the reliefs and the remedies provided for under the contract. But remember that termination is immediate. So the relief is not going to be for you to go back and do the works, no. The relief will be either damages or loss of profit based on what the arbitrator determines. It will inform on what you get, because then the employer has to be penalized for wrongfully terminating you, since it has been found that you are not fraudulent in your practices. So that's how I would put it. Also, lastly, Fabian, if you can allow me, is the dispute resolution clause is also very important in these kinds of contracts. So that's also something that you should look at when you're reading these contracts, and be careful on how the clauses are couched, so that you don't now throw your matter into court. Not that court is not important. I litigate, I am pro-court, but the nature of these contracts, you need to have mechanisms that can allow the project to keep running, and they don't immediately halt the project, because then you incur a lot of costs and losses. So dispute resolution mechanism is also a very important clause. Thank you, Fabian. Back to you.
Thank you very much, Patience. Our time is fast spent. I recognize the valuable contribution of the audience to this debate. Mr. Jackson Ojok, I see your comments and the thought-provoking questions, but we may not be able to respond to them because of the time factor. But perhaps I'll just take one question from Annette, a lawyer, and this will be our last question. You can reach out to our presenters after this webinar, and you can talk more about the questions that have not been able to sample. Alan, Annette is asking, as a follow-up question to you, Alan, isn't it the client's responsibility to have carried out due diligence prior to signing the contract? For him, prior to signing the contract, though for him to have no idea that the contractor didn't execute those works. I guess what Annette is asking is that isn't it the duty of the employer to conduct due diligence, and where he has not exercised due diligence, is he stopped? Is he prevented from going ahead and terminating the contract for reasons which he would have discovered by conducting due diligence?
Thank you, Fabian. Thank you, Annette, for that question. My answer before was to a question on the chat box, which was about fraud. But now that you bring this one, which is related to that, it is expected that an employer will have done thorough due diligence in the procurement. What I know is that most employers will do that. They will want to confirm, for example, where I work, we have to confirm. If you say you've done projects, we confirm by writing letters, and sometimes even visiting those sites to confirm that actually these projects were actually done by this contractor, or he had a substantial, some may be even subcontractors, those projects, or he had a substantial input to the work that was done. Let us say it could have been a big subcontractor. So for high value projects, I would really, really advise that please do thorough due diligence and do not come up with any excuse. Now, Annette, if you're doing thorough due diligence, it will be very easy to discover fraud. And even in the procurement process, if you discover any presentation that has been put in and packaged in the documentation as fraud, even if the contractor is the lowest firm, you automatically disqualify from the further assessment of that bid. So maybe this is something for those who are involved in selection of contractors for doing projects. Please pay attention to due diligence, try to check their books of accounts or go further, confirm with the auditors that they've done, check for historical non-performance, check with their previous employers. And we normally, sometimes there's the level of comfort if you receive, let us say, a letter from a big employer. Let us say, give an example, like Fabian's company says, no, I know this man is of good sound, then you will take that as that is how it is. But if you want further or you do doubt the recommendation or the reference that has been given, please proceed, go and check on site, check that the work is actually done. I don't expect that if you go through that rigorous process of selection, you'll get a shady contractor. Thank you.
Thank you very much, Alan. Mr. Philip Opio, I kindly request that you get in touch with Patience after this webinar over a cup of coffee, and she's going to take you through the conflict resolution mechanisms in construction contracts. Godfrey, I've seen your question and your comment. Thank you very much. We can always continue this discussion after this webinar. Well, ladies and gentlemen, that's the time we had today. We hope that you have found the discussion very insightful this afternoon. I know you have from the activity I can see in the chat box. A big thank you to our speakers, Patience and Alan, for generously and liberally sharing your expertise in construction with us. Big thank you to the audience for your participation, and a big thank you to Construction Law Institute for organizing this webinar. You can follow Construction Law Institute on LinkedIn and X under the name Construction Law Institute, or you can visit the website of Construction Law Institute to learn more. That's constructionlawinstitute.com. There you'll find information about the activities of Construction Law Institute, the upcoming events, the routes to membership in case you'd wish to be a member. It is not that it's only lawyers who are members of Construction Law Institute, but we have many engineers who are members, including Alan over here. Then Construction Law Institute is a supporting partner of the inaugural CIAB International Arbitration Conference, which will be held in Uganda from 13th to 14th of November, 2025. Mestil is where to be on 13th and 14th for the International Arbitration Conference. The recording of this event will be shared in the coming days. You've been a great audience. The speakers, you've been wonderful. We hope to see you again at our next event, but this is all we had for today. Thank you very much for attending. Before I close, let me just give a minute to each of our speakers to give a concluding remark, starting with Alan. 1 minute, please.
Okay, thank you, Fabian. Thank you for also being a very good moderator, and thank you to all those who joined. What I would maybe share with those who are still online is that please, if it's two things. One, avoid termination. Termination is very costly. If there's anything you can do, find all other resolution mechanisms to continue your project without terminating the contract. At the end of the day, these projects are meant to help people. Let's say, for example, most of the projects I work are water projects. We're supplying water and irrigation, and water for irrigation and for domestic use to farmers and residents. So any delay in a project, delay in an implementation of a project means that the service delivery delays for these people. So please, that's one. The second one, for those who are new, especially the engineers, please, I would encourage you to join the Construction Law Institute and also try to get conversant with the FIDIC. FIDIC, the 2017 Red Book, they are fast changing, but I think the 2017, if you understand it, all the clauses, go through it, and also read them together, the standard forms of contracts from other institutions like PPDA. And in that way, you'll be able to administer and avoid disputes in contracts. Thank you very much.
Thank you very much, Alan. Patience?
Thank you very much, Fabian. For me, my closing remarks, the first one is professionals. I think as depending on who you are, employer or contractor, please do your best to engage professionals in such contracts. And this should be from the drafting stage. Why is it important from the drafting stage? Because if you have poorly drafted clauses in your contract, then all your problems are going forward through the entire project, because you cannot now come back and try to amend and put better clauses. So for me, I would emphasize the need to hire the services of professionals. This could be an engineer, an architect, a lawyer. So depending on the needs of your project or the kind of work that you're getting into, please engage professionals to give you services. And I'm sure there are quite a number on the market, and you'll be able to get very good ones. The other one I will emphasize is contract management. Why contract management? You need consultants on the project as it's running who have the skill and the expertise to manage the contract. This is important because, like Engineer Alan emphasized, costs, money, time. These are the things at the crux of construction projects. So if you don't have professionals that are mindful or that they have the expertise in these projects, you're definitely going to face a lot of problems. So these consultants will help you with following the proper timelines, following the proper notices and the proper procedures. So contract management is very important. And then lastly, of course, it is for me to, like Alan has emphasized, termination should be the last option, to be honest. Why the last option? Because there are ample timelines within which you have opportunities to rectify these defects or these reasons why you can terminate. Because once you terminate, a lot of costs are going to be incurred. Let's say if it's a project like the ones Alan works on, the finances, you have to go back to the bidding process. You have to go through the whole process and lose a lot of money, but also the effect it has on the people that are meant to benefit from these projects. So I would say that as much as you can avoid termination, let it be the last resort. So for me, those would be my closing remarks. But I would also encourage our participants to please come back again, and we keep learning. Learning does not end. So we tend to have a number of these webinars. So I'd encourage our dear participants to continue to spare their time for us so that we can both continue to learn and grow from each other. Thank you so much, Fabian.
Thank you very much, Alan. Thank you very much, Patience. Best of luck to everyone, and we hope to see you again at our next event. Goodbye for now. Ciao.
Thank you, Fabian. Goodbye to everyone.
Thank you, Fabian, and goodbye to everyone.